Hello friends, in the series on income tax cases today we will discuss a very important issue which is based on the signature of the assessing officer on the assessment order. In the present case, a very pertinent issue was before the Honorable Bombay High Court, and the issue was that what is the date of becoming the assessment order operational, whether it is the date on which the assessment order prepares the assessment order, or the date which is there on the assessment order, or the date on which the assessing officer signs the assessment order. This issue has been decided by Honorable Bombay High Court in a writ petition in the case of Miland Darshat Pawar versus National Faceless Assessment Center, and this case is reported in 188 taxman.com 314, and the date of the judgment is 6th July 2026. In the present case, the assessment order was having a date of 13th April 2022. According to the Assessee, the date for passing the assessment order, the last date for passing the assessment order was 17th April 2022, and according to the revenue, the last date for passing the assessment order was 26th April 2022. But in the present case, whatever the date, whether it is according to the assessee, that is 17th April, or whether it is according to the department, whether it is 26th April, beyond these two dates, the assessment order was signed on 26th May 2022, and then it was served to the assessee through email. When the assessee received this assessment order, the assessee challenged this assessment order in the writ petition before the Honorable Bombay High Court on the ground that the assessment order has been passed beyond the limitation period for passing the assessment order, because the signature on the assessment order has been done on 26th May 2022. The revenue challenged this writ petition on the ground that since the assessing officer has put the date on the assessment order on 13th April 2022 and the DIN has been generated on the same date, so the assessment order is well within the limitation period. Now the question was centered on a focal point that whether having the DIN generated on the same date on which is the date on the assessment order, or whether the date of the signing of the assessment order which is valid for operationalizing the assessment order. When the court heard the matter, the court said that in the present case the facts are very clear that the assessment order has been signed after the due date of passing the assessment order, that is 26th May 2022. On this date the assessment order was signed, and if we take on the precautionary basis the date which is the limitation date according to the revenue, that is 26th April 2022, then in that case also the order has been signed beyond that date, so this order is barred by limitation. Friends, in many of the cases it has been seen that the assessment orders are prepared, the assessment orders are uploaded, and those assessment orders are not signed. There is every possibility that the assessing officers are not signing those assessment orders and their staffs are uploading, and they may get the signature after that. So whether in that case those assessment orders are valid which are uploaded on the portal, or whether they are sent to the assessee through email, sometimes the department takes the plea that whatever the assessment order was without signature or with the signature, there is no difference between the two, so there is no prejudice caused to the assessee, but signature of the assessing officer on the assessment order or any notice is a very vital part of assessment, so it should not be taken very lightly. So in the present case the same view has been supported by the Honorable Bombay High Court that the assessment order becomes operational only when it is signed by the assessing officer. At the end of this video, once again I am repeating the name of the case. The name of the case is Miland Darshat Pawar versus National Faceless Assessment Center, and this case is reported in 188 taxman.com 314. The date of the judgment is 6th July 2026, and the matter has been decided by Honorable Bombay High Court in a writ petition filed by the assessee. Thank you, friends.